Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale, which is based on your income. So that means the less you make, the less you pay. Today, I wanted to take a moment to talk to you about operating under the influence in Massachusetts. In Massachusetts, drunk driving is called operating under the influence. It's a very serious crime, as you can imagine. It's a very common crime that we see in the district courts every day. In order for you to be found guilty of operating under the influence, the Commonwealth, that is the prosecution, must prove three things beyond a reasonable doubt. They are number one, that you are operating a motor vehicle, number two, on a public way, and number three, at a time when you were intoxicated, therefore making your operation dangerous. So let's take a look at each of those elements individually. The first one is actually has two components, that you are operating a motor vehicle. So they must prove that you are operating a motor vehicle. So what is operation? Operation is the normal things that you think about when operating a motor vehicle. So driving, you're driving down the road, you're taking turns, you're braking, you're accelerating, you're doing all these things that is typical about driving. However, it's much broader than that as well. The case law in Massachusetts has come down that any action that you take in a motor vehicle alone or in a succession of actions which could tend to put that motor vehicle in motion is considered operating. So, for instance, there's an old case from I think 1934 or something like that, where there was a person that was in a car, and they had the old handbrake, and he took the handbrake off, and that pushed the car into motion, put the car in motion, and it was parked. It struck another car that was parked in front of it. That was considered operation because there was movement of that motor vehicle. The second part of the first step is that it must be a motor vehicle. So sometimes, very rarely, you get into a situation where you look to see if a particular vehicle is a motor vehicle. Sometimes you can look to see what the capacity of the engine is, for instance, if it's a moped or if it's a scooter or something along those lines, to show that it is a motor vehicle under the statute. The second thing is that it must be on a public way. A public way is any public street. So it's anywhere where the government maintains the roadway. So, for instance, interstate highways, state highways, city and town roads. They look to see if they're, if the governmental entity, plows it during a snowstorm or maintains the road. They send out crews and stuff to maintain the road. Clearly, those are all public ways and easily understood. However, it goes beyond that as well. It's broader as well, in that a public way is any place where the public has a right to be, either by invitation or just a right to be. So, in the jury instructions, the jury is told that things such as parking lots at government offices, gas stations, parking lots at malls and restaurants and so forth, the public has a right to be there. So that's considered a public way. Things such as private property, if it's your private property, for instance, and there are some certain other limitations on a public way, which you need to look at because it can be the outcome. It can determine the outcome of your case. And number three is that you have to be intoxicated. So intoxicated means that you have to have imbibed, if you will, or you have to have so much to drink that it's unsafe for you to operate that motor vehicle at that time. It's not illegal to drink and drive, as the jury instruction says. It is, however, illegal to drink so much and then drive that you're unable to safely drive that vehicle. So it's not illegal to have one drink and then drive your car, but you can't have several drinks to the point where that you're impaired, where it's unsafe for you to operate that vehicle. So all three of those things need to be present in order for you to be found guilty on a drunk driving or an operating under the influence. You'll hear it called OUI case. Um, the OUIs also get more serious if you have more than one as you go. So in a first offense OUI, Typically, if you don't take it to trial, you can probably work out a deal unless there's an accident or there's some other extenuating circumstances. The typical deal is you get a quaff, a continuation without a finding for a year. You have to take what they call the 24D program. That's a driver alcohol re-education program. You have to pay a lot of fees and fines. Your license to operate will be suspended for a minimum of 45 days. And you'll be on probation for a year. You'll have to complete all of those things and pay all your fees and fines. And at the end of the year, if you don't get rearrested and you satisfy all those conditions, your case can ultimately get dismissed. Once you get into a second offense, then that's different. You have to do a 14-day inpatient program at a hospital, and you'll be on probation again. There'll be other fines and fees, and then once you get, God forbid, if you're up to a third or thereafter, there is minimum mandatory jail time that's associated with that. And of course, these are just the minimum. So even on a first offense OUI, the maximum penalty you can get is 2.5 years in the House of Corrections. That's typically not what we see happen, but that is technically a possibility on an OUI first. So please definitely, first of all, don't drink and drive, clearly. But if you are charged with an OUI, please consult an attorney. There are a lot of moving parts to a criminal case, certainly, and you want to make sure that you're getting the best advice available. As I say, at Ford Law, we do practice criminal and family law throughout Massachusetts, and our fees are based on a sliding scale. We're trying to give voice in the courtroom to the hardworking men and women of Massachusetts. Please feel free to visit us at affordlaw.org. See if there are many resources available to you, frequently asked questions, and so forth. And while you're there, feel free to book a free virtual appointment with me. I'd be happy to answer any questions that you have about your particular case. At Afford Law, we're making justice affordable.